कोर्ट ऑफ लॉ करेगी, कर ही नहीं सकती है। मैं ये आपको कह रहा हूँ, मेरे हिसाब से ये कोई चीज़ भी कोई कोर्ट नहीं डिटर्मिन कर सकती, बिकॉज ये उनके जुमरे में आता ही नहीं है। कोर्ट डील विथ नॉट फिलोसॉफिकल कॉन्सेप्ट्स, कोर्ट डील विथ टेंजिबल थिंग्स। हाउ कैन यू डिटर्मिन समवन्स ऑनेस्टी? एंड इट्स अ वेरिएबल। अ पर्सन में बी ऑनेस्ट टुडे, डिसऑनेस्ट टुमारो, ऑनेस्ट टुडे, डिसऑनेस्ट टुमारो। I don't know, people keep changing. So these are not the kind of determinative things. Probably the 18th Amendment brought in the word through a court of law to virtually kill it off, but they didn't realize they probably created more of a mess than the original wording. I don't know, that maybe have been the intent. अब पार्लियामान ने काम कर लिया है, मुझे नहीं समझ आया, अगर उन्हें कर लिया है चलें, गुड लक टू देम। उन्हें का 5 साल, फाइन, why can't we live with it? I mean, जब 7 मेंबर जजेस कह रहे हैं कि ये सवाल या तो उनको अटेंड करें, आप इग्नोर नहीं कर सकते हैं कि जी आप, मैं दूसरा जजमेंट लिख दूं, मैं उसको इग्नोर कर लूं। जब बिल्कुल वही चीज़ें हैं, वही इशू है, वही इलेक्शंस की बातें आ रही हैं और आप उस तरफ चल पड़े। सॉरी, मेरे हिसाब से आई एम रीडिंग मोर एंड मोर ऑफ जस्टिस खोसरा's जजमेंट एंड आई फाइंड दैट द आंसर, यू कैन नॉट answer these questions. Not every question is answered. Some are answered in the hereafter. Some are answered, okay, if I take a vote today, no disrespect to you, is Mansoor Awan an intelligent person? Maybe some will say no, most will say yes, I can assume. So these are opinions. I mean, you may hold a thing on myself, they'll have an opinion on me. But it's not something that I can get a declaration from a court of law. Declaration of court of law means that you cannot have a second opinion on the matter. End. Khatam.
No, but having said that, the legislation that's come about is also ignored Ishaq Haqqani, because where is the answer to what kind of a declaration should it be? It just answers the time frame. That's a secondary question. The legislation should have thought that there's a Ishaq Haqqani raising all these questions. They should have explained where do we get such a declaration? How do we do it? What's the procedure as it mentions? But all these things are missing. So, I mean, we can't even get to the second question if we want to take it head on, unless we can come up with some sort of a sandwich definition of a
जवाब में मैं ये कह सकता हूँ, कल शायद पार्लियामान करने दें उनको अपना काम।
Fair enough. So I'm just saying that even if we were not to address this head on and come up with some sort of a sandwiched answer to a declaratory order or whatever declaration, it will lead to problems for the future again.
Now, at the end of the day, we have to establish one thing once and for all. Do you believe not just in election?
सुप्रीम कोर्ट को मुख्तलिफ आईनी सवालात का तयन करना होगा। अदालत फैसला करे कि नाअहली की डिक्लेरेशन किसने देनी है। अदालत फैसला करे कि कोर्ट ऑफ लॉ क्या है। समी बलोच केस में बेंच ने पुराने फैसले को नजरअंदाज किया।
People is reflected. The will of the people, whether they bring a constitutional amendment, whether they bring a legislative thing, it is the will of the people, whichever way you look at it. The next lot of parliamentarians will come, they will make a law saying this will be a lifetime ban, then we can consider its constitutionality. Our role should only be not to fill in the constitutional gaps if there are any. Our role should only be to examine legislation, does it accord with the Constitution? And I would go back, I may not even agree with Parliament, but I will keep quiet about it. As a voter, I may do something else. So why are we getting bogged down in this business? Why are we doing this job?
So if I may just address both of these questions, observation and questions. The declaration under 62(1)(f) has to be by a court of law, acting under a law or several laws. The law has to provide for which court will have to give that declaration, and then of course the entire process, including who will have the locus standi and the standard of proof which would be required for such declarations. Now what section 232 does is, and stops midway, is that it says that the procedure, manner and duration of qualification and disqualifications will be such as is provided under 62 and 63, and where there is no procedure, manner provided, it will be such as
The
is
legislature is actually not addressing that.
Now, this declaration question has been left open-ended. It has not been addressed.
It's not addressing the question.
It is not. Now, what it does is, it says that whenever that declaration comes out, the effect of that declaration would be for 5 years.
That's it.
That's the only thing it does.
How that will come out?
Yes.
Will come out.
So
I wish the wording was that the declaration is for that. It doesn't say that, but that's a separate issue. But I think that's a secondary issue. The main issue is, what do we do? I mean, we can't even say that this legislation has come up with an answer either.
So declaration subject to due process of law. ये लिखा हुआ है.
Due process of law, and then it says that the disqualification shall not exceed 5 years from the date of declaration.
I'll tell you what Parliament did.
Parliament has.
उन्होंने कहा हम इसको बस छोड़ो, इस बहस में पढ़ो नहीं, 5 साल कर दो, खत्म. That's in a nutshell what Parliament did. We can't tell Parliament to craft a law this way, because in my mind this is the best way to proceed. This is their job. Our job is another job. Is it unconstitutional?
My lord,
one proposition was put forward: do not touch upon 232. You may need to touch upon 232 at another juncture. I'm just speaking aloud for myself, I tend to agree with that. Nobody has challenged it. We assume it's okay till someone comes and attacks it. Maybe it's a very good attack. I don't know. Maybe they say, "Ki 5 saal bhi kyun?" I don't know. Let's leave all these things. The fact is, someone has applied their mind and made a law. And that law specifically mentions all judgments of any courts. So that law has shown us respect in the sense that they have just, like my Honorable Justice Afridi has said, it was not lifetime thing. So they have kind of brought it about by this legislation 5 years over. अब ये बहस किसी और दिन के लिए रखेंगे हम, अगर जरूरत पड़ेगी या नहीं.
And then also this important question.
What do we say about declaration?
Now, it seems that at the time of Samiullah, the court was pushed to do the work of the Parliament, and now again it is being presumed that we will do the work of the Parliament.
And court has not said for the permanent disqualification. It is only as long as the declaration will remain in field. Again, I will put you this question: why the section 232 cannot fix the period of that declaration?
It can, sir. Because, and I respond to
there
this.
is no inconsistency between the Samiullah and the Act.
Because 62(1)(f) has two components. One is this cause of this disqualification. This cause of this disqualification, and cause of disqualification is a declaration by court of law. So this declaration or this cause is rooted in law, resulting in a declaration by a court of law, and the consequence is constitutional, which is a person stands disqualified. Now what the Parliament has done is, it has limited and placed a certain limitation upon the cause, the declaration. The consequence stays where it is. Now the
declaration means the disqualification will remain in field for 5 years.
In this case, 5 years.
Section 232.
Yes. Yes, and if, for example, if there was no 232(2) and Samiullah is overturned, then the disqualification would only be for that election. For that particular election, which is declared either void or a person is de-seated based on that declaration. He would become eligible after if Samiullah is overturned. But this law then places a certain limitation. It gives longevity to that declaration of 5 years, which, to my mind, my lord, Parliament in its wisdom thought that if under 63(1)(h) we had provided 5 years at that time, then because this declaration is coming under a law and for that constitutional amendment is not required, it is only perhaps fair that we give a cooling off period of 5 years.
So what is the procedure to deal disqualification under section 60, under Article 63?
Sir, now when a declaration is come and if the question arises, a person has become disqualified, then chairman or the speaker under clause 2, the question goes to them and then they refer to election commission.
Under sub-article 2 and sub-article 3.
That's right, sir.
Article
That's 63. Right. That's right.
Mr. Ji, Article 62(1)(f) says court of law. Whether criminal court is not court of law, and why in Samiullah Baloch it was restricted only to civil court.
जी जी नहीं हो सकता। मेरा ख्याल है अब पार्लियामेंट उसका क्या फैसला करती है वो पार्लियामेंट ने उसका एड्रेस करना होगा, बट और अनलेस माय लॉर्ड्स आर माइंडेड टू होल्ड, बट इन माय रिस्पेक्टफुल सबमिशन इट कुड बी बोथ। इट कुड बी अ डिक्लेरेशन बाय अ सिविल कोर्ट और अ कन्विक्शन बाय अ क्रिमिनल कोर्ट व्हिच माइट एंटेल दीस कॉन्सिक्वेंसेस, बट दैट इज अगेन
जरा इस वक्त जारी है दलाइल देने का सिलसिला और इस पर बात करने का सिलसिला भी जारी है। चीफ जस्टिस के रिमार्क्स आपको बता दें, मैं आज लिख दूं रुकने पार्लियामेंट इंटेलिजेंट होना चाहिए तो